Story 1. Represented a man who stole 3 trucks from his workplace. Only 2 were recovered before trial. He arrived at a motion hearing in the 3rd truck. Story 2. I took my ex-partner to court because she had used my social security number to sign up for cable service. I discovered it when she stopped paying. At court, I submitted the contract from the cable company, which showed my social security number and her signature. She did not attempt to forge my signature. She signed her own name and then denied any involvement. The judge ruled against her. Story 3. Not someone else, my client screwed themselves. I handled a landlord-tenant case in which my client faced eviction for non-payment. My client had withheld rent because of habitability issues in the apartment. No heat, high lead levels, and vermin. This was going to be an easy win for me. I repeatedly told my client to keep the money and not spend it. If you show the judge you still have the money, it strengthens your claim that you withheld rent for legitimate reasons. When we appeared before the judge, the landlord did not have an attorney, so I was confident we could not lose. I presented my arguments, and the landlord presented his. The judge asked my client if they still had the money. My client replied, "No, I blew that money at the casino last week." Story 4. My wife is the lawyer. When children reach the age of majority, if they do not continue studying and begin working, it is not necessary to pay alimony. My wife's client found a new partner, which unleashed the ex-wife's wrath. She began asking for more alimony for the children. To win the case, it was necessary to prove the children were working, but they could not obtain proof. They had little chance of winning, but they went to court hoping that cross-examination would produce information to support their case. On the day of the trial, the children did not attend. Only the mother and her lawyer were present. Judge: Madam, tell me why your children could not attend. Mother: They could not get permission at work. A few seconds of silence. Judge: Well, that was fast. Story 5. I had a client who was trying to get away from an abusive ex and filed for a restraining order. He showed up to the final hearing and made a big fuss about a truck they bought during the marriage. He insisted it was his alone and that she had no rights to it because their marriage was void. On cross-examination, I asked what he meant by that. He said he had already been married in another state when he married my client. He said my client had no idea, and that this meant their marriage was invalid and the truck was all his. Not only is that legally inaccurate, the transcript of the hearing was promptly turned over to the police, who were actively investigating him for bigamy. The judge awarded my client the truck and issued a 2-year no-contact order. Story 6. Not a lawyer, but a friend kept meticulous records of how much time his estranged wife spent with their daughter. He used a pink highlighter for the mother and a blue highlighter for himself. The mother demanded full custody, substantial child support, and the house. The father produced 3 years' worth of calendars. The mother had spent less than a full month with the child during that time. She was not happy with the outcome. Story 7. I am a lawyer and saw someone screw himself. I work as a public servant in a criminal law judge's office. Since I have a law degree, I do not normally do administrative work, but I attend some hearings with the judge. Last month, we had a huge drug trafficking case. I am talking about 20 or more people involved, months of investigation, undercover agents, video and audio evidence. The hearing lasted 3 days. When it was time for one of the defendants to be on the stand so the prosecutor could read the charges against him, the defendant repeatedly stated throughout most of the hearing that he was not guilty, until my boss, the judge, told him to be quiet or he would be admonished. The defendant replied, "What are you going to do? Arrest me?" Which, to be honest, was actually a bit funny. As part of the facts of the case, the prosecutor said the defendant was being accused of selling, trafficking, and possessing a certain amount of drugs, with the base of the operation being his house, where he lived with his partner. Mind you, the partner was not in the hearing, she was not arrested, and there was nothing tying her to the case. The defendant interrupted and said, "Wait, I was the one selling the drugs. She did not do anything." His lawyer, a court-appointed public defender, facepalmed so hard that it was audible on the hearing audio recording. He still pleaded not guilty. Story 8. A witness for the plaintiff in a civil suit, who had been the plaintiff's co-worker, testified strongly against the company. I questioned her about bias toward the plaintiff, whether they knew each other well or were friends. She said no, they were just friendly coworkers, work friends at best, and I pressed her on that. When I cross-examined the plaintiff, she had no choice but to destroy her witness's credibility. Not only were they very close friends, they had become sisters-in-law a few years earlier. They did not share the same last name, but I had done my homework. I still don't understand why people try to counter minor bias by destroying a witness's credibility. It happens more often than you'd think. Story 9. I am being sparse on details due to confidentiality. I had a client accused of a very serious sexual offense. He had an alibi. He was at work as the boss and an employee could vouch for him. When I first spoke with the employee, he confirmed the alibi. As the trial approached, I needed to file an alibi notice, which is advance notice to the Crown prosecutor so they can investigate the alibi. To be careful, I called the employee again. It turned out my client had fired him in the interim, and the employee told me candidly that, although my client had been at work, he would not say that in court and would testify against him. I did not call the employee as a witness or file the alibi notice. We still won the trial, but if I had not thought to call him, or if he had been less candid, my client could have been ruined, registered as a sex offender, jailed, the works. He was completely innocent. Story 10. I have seen too many criminal clients sabotage themselves. One of the few family law cases I handled as a young attorney stands out. A young woman and a young man had a child. The woman sought a divorce because the man embraced the thug life. He had recently been arrested and charged with possession with intent to distribute methamphetamine, a felony, and unlawful possession of a firearm. He did not want her to leave and hired a prominent local divorce attorney. The court entered a temporary order prohibiting the mother from having overnight guests of the opposite sex. The woman began seeing a new boyfriend. The man was very upset and, through his expensive attorney, moved for a hearing, accusing her of violating the order and seeking full custody plus attorney fees. On a friend's recommendation, the woman hired me for the hearing. I met opposing counsel who tried to intimidate me with her experience and demanded the mother give up primary custody, have only supervised visitation, and pay child support and attorney fees. She knew I was a new attorney. I refused and she said she would see us in court. At the hearing, I had a copy of his probation terms for his conviction for possession with intent to distribute methamphetamine and unlawful possession of a firearm. He had not told his attorney about that, and she did not know. She questioned him and established that my client had her new boyfriend over on several nights. The judge was conservative and not pleased. Opposing counsel then passed the witness. I asked him whether he had a job. He said no and that he did odd jobs. I asked whether he sold methamphetamine. At first he denied it, but I introduced his guilty plea and probation sentence. The judge was staring daggers at him. I asked my client quietly if she would be completely clean if she took a drug test that day. She said yes. I then asked the man when he last used methamphetamine. He repeatedly said he had been clean for years and that a test would be negative. Opposing counsel asked the same question of my client. We agreed she would test clean. The judge ordered drug tests. The man tested positive for methamphetamine and my client tested negative. The judge denied his motion, ordered new temporary orders requiring the man to maintain employment and begin paying child support, and placed him on supervised visitation. Afterward, opposing counsel called me and left a voicemail congratulating me and saying I had handed her ass to her for the first time in a long time. Story 11. More of a case of him screwing himself over, but here goes. This was a case another prosecutor in my office had a few years back. A 30-year-old defendant was charged with sexual assault of a child after he got his girlfriend's 14-year-old sister pregnant. The sister kept the baby, so the police waited and obtained a paternity test. Not surprisingly, the defendant was the father. The defendant wanted probation, but the prosecutor refused to offer it. He decided to plead guilty and have a jury trial on punishment. In Texas, a defendant can choose to have the jury set punishment. The evidence proceeded mostly as expected. The victim testified that she had consensual sex with the defendant, aside from being under the age of consent, and that she became pregnant. The paternity test was admitted into evidence. The defendant testified. He claimed that he snuck into the victim's room at night, covered her mouth, and held her down while he forcibly had sex with her. It appeared that his own lawyer was unaware of the story he planned to present. The jury deliberated for about 15 minutes before returning a punishment of 17 years. The maximum possible under the charges was 20 years. Afterward, when interviewed by the attorneys, one juror said they chose 17 years so the defendant would never forget the age of consent in Texas. Story 12. I'm not a lawyer, but this happened to me and some friends in college. A group of us rented a 5-bedroom house and, being the group we partied hard and were rough on the place. We knew going in we would not get our security deposit back. Partway through living there, the septic system started to have problems. The downstairs shower drained slowly. The tub would gradually fill while in use. The carpet in one of the rooms would also get wet. We emailed the property management company to request a repair. 2 weeks later, they sent a plumber to snake the line, who left when he was done. That did not fix the problem, so we emailed again. 2 to 3 weeks later, another plumber came, snaked the line, and left. Still not fixed. After another 2 to 3 weeks, they scoped the line and discovered tree roots had grown into it. They had to perform a major procedure to remove the roots, and that finally fixed the system. We all moved out and went our separate ways. One friend went to Australia for 9 months. When he returned, he found several voicemails. The property management company was seeking about $5,000 in addition to keeping the deposit. They pressured him to pay or face court. He told them he would see them in court. In the months before the court date, he kept getting calls demanding payment, saying it would go away if he paid. The day before the first court date, they called and told him to pay $2,000 and to provide contact information for another person on the lease. He refused. The first day of court was only to confirm attendance and schedule the actual hearing. The property company's lawyer appeared but had no records beyond the original lease, which had changed as people moved in and out. My friend provided copies of the multiple emails we had sent requesting repairs and documenting the damage. The lawyer said he would let us know how they wanted to proceed. We never heard from the company again. Story 13. Someone I knew had a pro bono case defending a person charged with a criminal offense. I do not know the details. The charge was confidential. Although the police and the district attorney could largely pinpoint the crime to her client, there was no evidence tying him to the offense. The case was circumstantial at best. She instructed him to remain silent and let her handle the testimony during the trial because, from experience, the client sometimes did not know how to answer questions. She pleaded and argued that the court had no evidence against her client. For once, she thought a pro bono case was going her way. After her plea, the judge thanked her and turned to the client. He asked whether the client had anything to add. The client looked at her, then at the judge. Tears welled in his eyes, and he blurted out that he was sorry and would never do it again. She threw her notes and everything else she had at him. He had effectively ruined both his defense and his case. Pro deo is an old term for pro bono. Story 14. Not my story, but a former boss's. They handled a case in which a drunk driver killed the occupants of a car. My boss represented the surviving father. His wife and 2 children had died. He wanted the college student's drunk driving to be exposed. This was before Facebook was commonly used in court and before many people realized social media is too valuable for any attorney to ignore. At the first hearing, the college student earned the judge's sympathy by apologizing, saying he was haunted, that he would never drink again, and that this would ruin his life. The judge seemed to accept it. Then my boss destroyed the student's display of remorse by presenting numerous Facebook posts and photos showing binge drinking, partying, and even joking about driving drunk from the date of the accident up until the night before. The student looked like he was forced to swallow hot coals, and the judge was furious. The student had to do far more than apologize and appear remorseful after that. Story 15. This was my father's case, not mine. He was the equivalent of a public defender decades ago. There was a man who would get caught drunk in public, commit public lewdness, etc., every weekend. He tended to draw the same judges and was well known in the courthouse as an absolute lost cause. One of the regular judges had him appear in his court again. The judge was ready to give him a prison sentence because this time he had been driving a car. But the man began to cry that he finally got a job out of town and was trying to turn his life around. The judge told him that as long as he never made a mistake in my town again, he would drop the charges. Sure enough, the man showed up the following Monday in the same judge's court, driving drunk again. My father had the case. The judge reminded him he had been given a final chance, to which the man sobbed, "I was leaving town, Your Honor, but my friends decided to throw me a going-away party." The judge was not amused. My father had to do everything he could not to laugh. In summary, a habitual drunk who had driven drunk was given a chance to leave town without charges, got drunk at a going-away party held for him, drove, and went to jail. He faced the same judge both times. Story 16. I am representing an elderly woman in a case and will be sparse in details to protect her anonymity. Briefly, her neighbor convinced her the house was unsellable, that it required extensive repairs that would bankrupt her, and that she should sell it to him. He came the next day with documents to sign. She did not understand what was happening, did not read the papers because she has an eye condition, and signed everything. When she finally saw a lawyer to close the deal, the lawyer exclaimed that the sale could not go ahead. The transaction price was about 36% of the house's true value, and the required repairs were minor, such as fixing a bathroom faucet. She did not realize she would have nowhere to live afterward. She believed she could remain in the house until she died. She lives on a modest pension, and the opposing party is suing to enforce the sale. They are trying to force her to concede because her legal fees are mounting. I hate people. Update. To answer a few questions. 1. We have a lot in our favor, but there are many steps before trial. By the time we reach trial, she will have to spend a lot of money she does not have. 2. She has an eye condition, uveitis, but it is not severe enough to qualify as a defense of non est factum. At the time, she was driving. 3. She is a poor witness. Her evidence is inconsistent. When deposed, she denied being taken advantage of, which weakens our position. 4. In Ontario, where I practice, contracts for the purchase of real estate do not have to be notarized. Update 2. Thank you for the interest. We settled this afternoon so my client can live in peace. She will have slightly more debt, but nothing that will bankrupt her. Thank you for your support. Story 17. I have a favorite moment to share. Excuse me if it is already on Reddit. I was litigating a custody dispute on behalf of the mother in an incredibly conservative jurisdiction. One common tactic to obtain custody was to allege sexual or pornographic addiction because the threshold for proving it was essentially non-existent. For this hearing, we lucked out with the judge, whom I knew from other cases. Opposing counsel tried to trap me into settling before the hearing by presenting surprise sexts between the mother and her new boyfriend. You cannot introduce surprise evidence, so we went forward with the hearing. I objected to the sexts, but said I would allow them to be read into the record in their entirety. The very conservative local attorney spent the next 25 minutes reading the sexts in open court, occasionally asking if she could gloss over parts, but I did not allow it. I will never forget her struggle with the word nipple. This was the third hearing to modify custody because the father believed his ex-wife having a boyfriend made her a sex addict. They alleged the sex occurred while the child was in the mother's custody, basing that on the timestamps of the screenshots. The timestamps showed the texts were sent when the child was not present and the mother was free to communicate by phone. The judge had heard enough of the father's behavior, awarded attorney fees, and included in the order, consistent with the vexatious litigant statute, that the father would be liable for the mother's attorney fees if he continued to pursue these claims. It was the only joy I found in practicing family law. Story 18. I am not a lawyer, but I sat on the jury of a man accused of molesting his 10-year-old niece. He elected to testify in his own defense, and his defense was, I did it, but it was her idea. It was his third felony strike, so he will likely spend the rest of his life in prison. Story 19. Not a lawyer, but this story always gets me. My biological grandmother died 20 years ago of ovarian cancer. She left all her money, trusts, and bonds to my grandfather to use during his life and to distribute after his death. My grandfather remarried about 15 years ago to my step-grandmother. My grandfather died a few years ago. My step-aunt is greedy and lives on the opposite side of the country. She lived off her mother and my grandfather for most of her life. She would bring them on vacations where she used their money to buy herself things and take free skiing trips about 8 times a year. After my grandfather passed, my step-grandmother had to move to live near her children to get care for dementia. My step-aunt had access not only to her own mother's estate, but also to my grandfather's to cover her needs. That was not enough. She decided to try to sue my dad and uncle for the estate of their deceased biological mother. My dad is paralyzed and uses a wheelchair. My uncle had a triple bypass, has a pacemaker and multiple stents. Both are on fixed disability income. On the court date, I wheeled my dad in while my uncle walked with a cane. My step-aunt is able-bodied and has access to the millions that my step-grandmother and my grandfather earned over their lives. The judge took one look at the situation and denied her access to my biological grandmother's estate. We were there for less than an hour. Story 20. Not a courtroom, but a live police department traffic stop I was watching. The driver told the officer that he had caffeine pills in his back pocket, took them out, and placed them on the hood. Everyone was calm. Then he admitted the pills were actually Molly. The officers looked at each other and one asked if they even had a test kit for that. The other officer said no. The man's expression made it clear he should have kept his mouth shut. Story 21. I was a very new lawyer with no bankruptcy experience. A partner sent me to bankruptcy court to try to make a claim as a creditor related to a building worth $50 million that was being sold. Time and lack of knowledge will prevent me from accurately describing everything that happened, but I will do my best. The court handled my client's claim very quickly and easily at first. The court ruled we were not a creditor because our claim was against a tenant, which was correct. We had purchased the claim from someone merely to try to wedge our way into buying the property, which was very transparent to the court. So I could just sit back for the remainder of the hearing and watch two prominent bankruptcy attorneys go at it. One represented the debtor and the owner of the building. The other represented a secured creditor with a lien against the building. They absolutely hated each other on a personal level and were arguing with great venom about the plan to sell the real estate. There was a small break in the action while the judge took care of another matter. When we came back, the secured creditor's attorney told the court the following. His client had purchased a controlling interest in the debtor, the owner of the building. He had been directed to fire the other attorney. He had been directed to withdraw the motion to sell the real estate. He then did both there in the courtroom. I have practiced for almost 3 decades. It was the most remarkable thing I had ever seen, particularly noteworthy because the courtroom was packed with other attorneys watching. Story 22. Not a lawyer, but this happened to my family. My husband's children asked us to fight for full custody after years of systematic abuse by their mother. My stepdaughter was sexually assaulted, and her mother married a man who was best friends with the assailant. The mother never told us, never sought counseling, and never reported the assault to the police. In mediation, she denied that a conversation had ever happened and began telling lie after lie. My husband said simply that I had spoken to her to explain how uncomfortable our daughter was living with this man because he was connected to the sexual assault. The mediator was not amused. She said there was someone living in the house who was connected to the daughter's assault, and that the mother's relationship with her children was broken. She spent the rest of the session sobbing and signed away custody because this was just the tip of the iceberg of what we had on her, and she knew it. Hearing her sobbing made me so happy after all she had put these kids through. I had to walk my stepdaughter into the police station to report the sexual assault. I usually don't want people to suffer, but after warning her that this man would come between her and her children and then her lying about the context of that conversation, I'll make an exception. I tried to stop the chain of events that led us to court, and she tried to use it against me. Story 23. Sitting and waiting for my client, the judge was giving a group colloquy for an alternative program on a driving under the influence offense, basically probation. The judge asked whether anyone had consumed alcohol or taken drugs in the last 24 hours. Putting the obvious answer aside, one man proudly raised his hand and said he had smoked marijuana the previous night. He did not get probation. Story 24. It was self-defeating. The Motion Picture Association of America included, as evidence in their lawsuit, the code by the hacker known as Digital Versatile Disk John that broke Digital Versatile Disk copy protection. That code became part of the public record and was available to everyone, undermining the purpose of the lawsuit. Story 25. I am not a lawyer, but there was a case in my town between a father and son that was hilarious. The father is a well-known personal injury attorney who started his own firm under his name, George Sink. His son joined the family business, but they had a falling out, so the son left to start his own firm and used his father's name. The father is now suing the son for using the name he gave him to start a law firm. Story 26. Not someone else, but himself. He and his lawyer missed court appearances, sometimes one, sometimes both, with little or no warning and suspicious excuses. We kept pointing out holes in his story. He claimed he left the country without knowing about the court date, but his lawyer told the court he had been informed beforehand. He suddenly said he was in a former Soviet bloc country for fertility treatments and that returning would ruin everything. He claimed he was visiting dying relatives on another continent. He said he was heading to the airport when he had to rush to the hospital and produced an admitting form in another language that we translated. It showed he had been admitted but also discharged. He also tried to fire his attorney, claiming he needed more time to brief new counsel, who at the next appearance said he had not been able to talk to his client and needed an adjournment, or that he had not been paid and that the client was difficult and he should be relieved. We kept telling the judge he was stalling, but the judge gave him the benefit of the doubt. We even showed prior cases where he skipped appearances and judges threatened sanctions. Finally, he failed to appear at a hearing where the judge had specifically ordered him to be present, saying, "I don't care if you're meeting with the Pope. You must be here." As a result, his answer was stricken and a default judgment in full was entered against him. Neither he nor his lawyer attended the hearing where the judge determined the amount of the judgment. And then he had the nerve to file a motion claiming the judgment was unfair because he had no chance to dispute it. Story 27. Not a lawyer, but my father is a physician and is sometimes called as an expert witness in malpractice cases. In one memorable case, a family sued a doctor over a fairly frivolous claim, and my father was a defense witness. The family's lawyer cross-examined my father, produced a chapter from a medical textbook, and asked him to read a highlighted paragraph. He did, and the lawyer said, "So, what you just read means the passage supports the plaintiff's claim." My father replied, "No, it does not." The lawyer said, "No, but if you read this section, the author clearly states the same conclusion." My father said, "No, that's not what the author means." The lawyer asked, "How do you know that's not what the author meant?" My father answered, "Because I wrote it." The judge face-bombed while the lawyer froze and stared at the author's name on the chapter. It was the best moment of my father's professional life. The ruling was in the defendant's favor. Story 28. I am a paralegal. The best situations are when we get a sovereign citizen, someone in the United States of America who thinks that United States laws do not apply to them for a variety of reasons, who hires us but will not let us do anything on their case. We have had to fire several clients because they violated our rules, such as do not send a letter to the judge, do not write your own motions, and do not announce that you are not Mark Smith because Mark Smith is capitalized and they claim to have been born with lowercase letters. A whole thread on these people would not be enough. Story 29. This was not my case, but I followed it closely because it involved an acquaintance's divorce. He and his wife at the time shared a commercial property that was worth a lot of money. They were both on the paperwork and had access to the same information. When serious problems arose, the property fell into arrears and I believe a lien was filed. The husband tried to discuss the situation with his wife, but she ignored him and the finances and began an affair. At divorce, the proceedings were contentious. They fought over the primary residence, whose unencumbered market value was much less than the commercial building. She demanded the house and the husband effectively offered to give her the commercial building if he could keep the residence. She had not paid attention to how bad the commercial building was, and for some reason her lawyer did no due diligence, so they took the deal. I do not know whether the asset allocation included any safeguards or caveats for the ex-wife, but it appears her disinterest led her to accept an underwater property instead of a paid-off house. Story 30. A wife filed for a restraining order because she wanted the house during a divorce. The husband had a good job, earning about $200,000 per year. When his employer learned about the restraining order, he was fired. He was a highly specialized employee, so the only job he could find close to the house, his ex-wife, and his daughter paid $50,000 per year. The house was foreclosed. Child support was less than $500 per month. The wife had to take a job as a waitress, for cars were repossessed. Story 31. I remember when I was a kid, my dad got a ticket for running a stop sign. He decided to fight it because the stop sign was buried in a bush and was not visible from the road. He and the police officer who had issued the ticket arrived at court on time, but the judge was not there. After about 20 minutes, the bailiff apologized and told them they could go home and that the matter would be rescheduled. Shortly after they left, the judge arrived and found both my father and the police officer in contempt of court for leaving and accused them of wasting her time. One $80 traffic ticket became two $500 contempt of court fines. About 5 years later, a friend of mine was charged with driving under the influence. It was caused by prescription medication, not alcohol. He did not realize he should not be driving while taking it. He went to court without counsel. The judge told him that if he insisted on representing himself, he could remain silent. So he said nothing and lost his license for a first offense of driving under the influence. There were several news articles and letters to the editor about what a disastrous judge she was, so I am sure many other people had similar issues with her. Story 32. Not a lawyer, but this is my personal story. When I was 4, I had 3 older siblings, 2 brothers, aged 10 and 13, and a sister aged 7. My dad was fighting for custody of all of us because we only spent weekends at his house, and during that time we would all complain about the bad things that happened during the week with our mother. Ultimately, the judge ruled that the children were old enough to decide where they wanted to live. My sister made the choice for me. My mom, knowing she would lose all of us, stood up in court and said, "You can have all of them, but she is not even yours, so you cannot have her." My entire family was there. Nobody understood why she would say that. Many people were crying and my dad was in a state of shock. Because of this, the judge ordered a deoxyribonucleic acid test, but either way the children still got to choose at the next court date because his name was on all of our birth certificates. I guess she forgot that. The judge gave this extra time because of my dad's condition, just in case the result changed anything for him and whether he would still want custody of me. My mom was not fond of any of us, especially the boys, whom she had already written off as a lost cause. She would no longer receive benefits or money from my dad, so she needed at least some children to live with her. She used that time to convince my sister that, with her brothers gone, she could afford all the things she wanted. Ice cream, toys, later bedtimes, you name it. My brothers chose my dad and my sister chose my mum. I had a pretty rough upbringing because of her decision, and to this day she regrets it. She was never treated differently. No treats, no toys. It turned out my mum was not lying. He was not my biological father. Courting. To my family, this was a huge burden for him for a very long time. He remained an incredible father in my life, but sometimes something would happen that caused an odd or upsetting reaction from him, and that was the sole reason. It really changed his and my life. I'm not a lawyer. Story 33. Not a lawyer, but I was a jury foreman on a case about 5 years ago. A man was accused of attempting to kill his girlfriend. Various charges of varying severity were filed. However, the victim's testimony was not terribly convincing, especially after cross-examination, and there was only evidence that something had happened in the house that night, not necessarily that the boyfriend had done it. It was the defense's turn to present, and they unexpectedly recessed for the day. We came back the next day, and the defendant testified. He placed himself at the scene and admitted to hitting her. We ended up convicting him of everything except attempted murder, if I remember correctly. Afterward, the judge came into the jury room and told us that the unexpected recess the previous day was because the defendant insisted on testifying against the advice of his lawyer and the judge. If he had not testified, there would have been essentially no chance we would have convicted him. Play stupid games, win stupid prizes. Story 34. I am not a lawyer, but my parents got divorced a few years ago. Summary at the end. Short backstory. My father is a narcissistic, emotionally abusive man. My mother was a stay-at-home mother until I turned 16. She then entered the workforce at minimum wage and worked up to a management position. My father worked a trade job at an auto company, making 3 to 4 times as much as she did in the 6 figures. At the beginning of the proceedings, my mother tried to settle early. She wanted enough to cover health care because that was her biggest financial worry. My father wanted to give her nothing. Things became very nasty. He hired a terrible lawyer who constantly insulted my mother to her face, which pushed her to ask for much more than she originally wanted. His lawyer told him my mother would not get a penny. After a year of litigation, the judge handed down the final judgment. My father must pay $1,500 per month. 3 days after the judgment, my younger sister was at my father's house. My mother picked her up and asked why he had not gone to work yet. My sister went inside to check on him and found him barely breathing with vomit everywhere. He had acetaminophen poisoning. There was an empty bottle of hydrocodone and acetaminophen, and another large bottle of acetaminophen on his nightstand. Doctors said there was no way to be 100% certain how much he had taken because he had gone to bed early and my sister had not seen him for over 12 hours. However, based on the amount of drug remaining in his blood and the degree of organ failure, they said they were 70% sure it was an intentional overdose. He did this before putting his brand new car solely in his name and before any other payments to my mother were made, aside from splitting the proceeds from the sale of our house. When my siblings and mother later argued with his sisters over who would make his medical and financial decisions, we discovered he had written a check to his sister for $75,000 with a note that said, "Don't let the girls have this," referring to my mother and sisters. A judge appointed a third party to make decisions for him because the appointment was contested. That person waited nearly 2 years before allowing the car to be repossessed, which damaged my mother's credit. My sister, who was only 16 at the time, is still dealing with post-traumatic stress from finding him. This is the short version. My father still lives with lasting effects similar to a severe stroke. He is in an assisted living facility, and none of his children have any contact with him anymore. Summary. Attempting suicide to avoid alimony payments was the worst thing I have seen someone do to harm someone else in court. Story 35. I have been in dispute with British Gas for around 10 years. They take me to court occasionally. Each time I win and we go away for a few years. The last time I hired a solicitor, the case was in a magistrate's court even though it was a civil matter. My solicitor waited for the British Gas representative to swear to tell the whole truth and then asked him what he knew of the previous court cases. When the representative said he did not know anything about them, my solicitor challenged his credibility, pointing out that he had just sworn to tell the whole truth, so nothing he said could be trusted. It went on for a few minutes and was rather brutal. The magistrates agreed and we walked away with £600 in costs. It was a joy to watch the man who had said, "We are going to make entry to your house and the police will help," before we went in, be told to sit down and not say anything else unless he was asked a question. The dispute concerns a disconnected meter at my house that supplied electricity to a closed shop. I have written to the chief executive officer, involved my member of parliament, and been to court 4 times. British Gas does not change or listen, so I have given up. I will just go to court occasionally and claim my £600. I remembered that they had to transfer the money electronically because we were going to send the bailiffs in, since they took 27 days to pay. To be honest, I was a little disappointed when they paid. Story 36. I am not a lawyer, but when my father-in-law and mother-in-law got divorced, she wanted to file a joint return for the previous year because they were still married. They would have received a decent refund. He insisted on filing separately, even though he would owe $4,000, because he wanted her to also owe the Internal Revenue Service. He did it to frost her ass. Story 37. The defendant, seeking to overturn a default judgment, claims the person the process server served was not him. At the hearing, the process server testified that he clearly recognized the defendant in court 2 years later because the defendant physically threatened him at the time of service, making himself memorable. The process server was certain he served the correct person because he had a photo of the defendant at the time of service that my client had sourced from a public mugshot website. Story 38. I am not a lawyer, but my ex seriously harmed her case in our divorce proceeding. Right after we separated, we both moved in with family. School was not in session and we did not have any custody agreement yet, so we had been swapping the children every week. One day, while the children were with her, she emailed me and told me she had enrolled them in a school near her. As soon as I received that email, I contacted my attorney. He filed a motion for a temporary custody order until the divorce was final. When he obtained a hearing date, he served her and filed the paperwork with the court. On the day of the hearing, we waited in court and she did not show up, so the judge granted me temporary custody, which eventually became full custody when the divorce was finalized. I later learned the reason she did not attend. She thought my attorney was trying to trick her. She said she had called the court about the hearing date and was told a different, later day, which fell on a Sunday. I found this baffling. If she believed my attorney was trying to trick her, why would she expect an earlier date rather than a later one? Why not show up anyway? If the date she had been given was false, she could still have attended the real date. If it was real, she should not have missed it. And how do you not notice it falls on a Sunday and question it? The kicker was that she had not actually tried to enroll the children in a school near her. She had said it because she was angry about something I had said, although I do not remember what. Story 39. Not a court case, but it is legally adjacent. My father is an executive safety officer at his company. One of the company's truck drivers was involved in an accident. The driver was not at fault, but company policy requires testing any driver involved in an accident the same day, and he failed the drug test. He disputed the results, so they had him retake it. The sample he gave them was not warm at all. It had clearly not come directly from his body. In the testing facility bathroom, which they meticulously cleaned between each test, staff found a strip of tape and a small vial and cap that would fit a small vial. My father joined a conference call with the driver's manager, and other relevant parties. The driver maintained his innocence, and they could not conclusively prove that the tape or cap showed he had cheated, so they were at an impasse. As they were ending the call, my father asked the driver casually, "Doesn't taping a vial to your leg hurt? How do you get it off?" The man replied without missing a beat, "No, it was just painter's tape. It comes off easily and did not hurt at all." There were about 5 seconds of dead air before the man panicked and tried to put the toothpaste back in the tube. The company was able to terminate his employment without difficulty. Story 40. I am not a lawyer, but this case got pretty big when I was serving in the United States Navy because it involved a sailor. A submariner divorced his wife. The ex-wife originally received custody of their son because of the submariner's deployment schedule. She later lost custody after being convicted of child abuse and neglect. She objected because that ended her access to financial support. The submariner began a relationship and gave his girlfriend temporary guardianship of his son during deployments. They were stationed in California, and the ex-wife lived in Michigan. The ex-wife waited until the submariner deployed and served him with custody papers in Michigan, arguing again that his schedule made him an unfit custodial parent. The trial was scheduled for the following month. Because submarines surface only every couple of months and have very limited communications while underway, submariners commonly grant power of attorney to family members or significant others. The court papers were served and the trial proceeded while he had no way to communicate. The presiding judge sympathized with the ex-wife, favored the idea that children belong with their mother rather than with a non-parental woman, and discounted the abuse conviction. The ex-wife was granted custody by default, and the judge attempted to hold the submariner in contempt of court for not appearing. When his chain of command learned of the situation, they intervened. It is unlawful in the United States to punish a service member for missing a court date due to military operations or deployments. The chain of command contacted the Judge Advocate General's office, which assigned the submariner a military lawyer. His attorney appealed to the Michigan Supreme Court. The original judge was later removed from the bench, and the ex-wife was ultimately found permanently unfit to care for children. Story 41. I had a criminal jury trial for misdemeanor criminal mischief over 4 years ago. The state filed charges and kept amending the information until the actual victim was left out of the trial and the case proceeded with 2 eyewitnesses. One witness was my client's ex and the other was the ex's new girlfriend. They claimed my client had vandalized the actual victim's car, and my client denied the allegation. Apparently, the state and both witnesses did not know the ex had an outstanding warrant for failing to pay child support owed to my client, which created a motive to lie. On the stand, I asked the ex if he was aware of the warrant. He said he was not. The judge excused. The jurors and the bailiffs arrested the ex in the courtroom. The state rested. The judge granted our motion for judgment of acquittal because we had strong case law regarding the absent victim. My client was acquitted and walked free, and the ex was taken to jail. Thanks a bunch for sticking around till the end of the video. Remember to subscribe, and until next time, stay awesome and goodbye.